In a few moments, the clerk will read you a redacted version of the amended indictment in this case. That document is not to be considered as evidence. It sets forth the charges against the defendant. You must not consider it as evidence of guilt and not be influenced by the fact that charges have been filed. Mr. Daybell has pled not guilty to the charges contained in the amended indictment. And please remember, again, it's a description of charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be or what any lawyer may state the law to be. During this course of the trial, including opening statements, you're instructed that you are not to discuss this case among yourselves or with anyone else, including using the internet or social media or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. And do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. The court's given you that instruction now multiple times, and I will continue to give you that instruction. And again, that's not because I don't think you're not paying attention. It's just important enough. We'll keep reiterating that. And I will note we received the juror affirmations today from each of the jurors indicating they have followed that instruction. So thank you for that. At this time then, the next matter we'll take up is to have this jury placed under oath for trial. At this time then, Clerk, if you're ready to administer the oath, I'll have the jurors stand and be placed under oath. When you stand, then please raise your right hands.
You solemnly swear or affirm you will try the cause now on trial and a true verdict rendered here according to the law and the evidence. So help you God.
All right, thank you. Please be seated. All right, the jurors have already been advised of some of our trial procedures in this case, and I'll just give you some additional general information here. Our normal schedule is to run trial from 8:30 each day until 3:30. At times that will need to be modified for certain reasons. Sometimes we have matters to be argued outside of your presence. Sometimes during the recesses, they may seem to go long because we're conducting other court business outside of your presence. But we will take recesses through the morning and also in the afternoon. If anyone is uncomfortable, needs a break or recess for some specific reason, please notify the bailiff and we'll do our best to accommodate each of you and keep you comfortable while you're here. In addition, if anyone has any kind of accommodations they need, for example, assistance with a hearing device, other matters, please notify the bailiff again, and we want to make sure you are as comfortable as you can be and able to be alert and attentive throughout the presentation of evidence in the case. These seats that you have been assigned to at this time will be your specific seat throughout the trial. Please return to that same assigned seat each day or after each break so that we are able to determine who's here and if someone's not for some reason, who's not here. If there are interruptions at times during the trial, I know that can be frustrating, but we'll work our best to keep those to a minimum, move the trial as long as efficiently as possible, but at times it just takes time to hear motions that are necessary outside of your presence. And then the courtroom and your location for deliberations, as well as during the trial where you'll be held. We've provided, of course, access to restrooms and other needs you may have. I'll address your compensation here. State law allows you for $10 a day for your jury service. However, after 5 days, that bumps up to $40 a day. So this trial is expected to go some time. You'll likely get into that increased range of compensation, and that's pursuant to Idaho Code 2215. You're also entitled, I believe, to a mileage reimbursement for travel each day, and that can further be explained to you if you have any questions. Also, you may notice from time to time, or a lot of the time, I'm looking at monitors here during the trial. I do have case information here and availability to access and research things from the bench. And so if you notice me looking at those monitors, it's generally to assist me in trial issues that come up. At this time, then the court will provide the jury with some additional jury instructions. As I read through these, it's somewhat lengthy, and I will notify you that you don't have to necessarily memorize everything I'm saying. When the trial is concluded and you deliberate, you will have printed copies of these instructions to return to for reference. And if you'll give me just a moment here, I have a brief inquiry to make with my staff attorney.
Hi, little shoe. Good to see you.
All right, thank you. Now that you've been sworn as jurors to try this case, I'll go over with you what will be happening. I will describe how the trial will be conducted and what we will be doing. At the end of the trial, I'll give you more detailed guidance on how you are to reach your decision. Because the state has the burden of proof, it goes first. After the state's opening statement, the defense may make an opening statement or may wait until the state has presented its case. The state will offer evidence that it says will support the charges against the defendant. The defense may then present evidence that is not required to do so. If the defense does present evidence, the state may then present rebuttal evidence. This is evidence offered to answer the defense's evidence. After you have heard all of the evidence, I'll give you additional instructions on the law. After you have heard the instructions, the state and the defense will each be given time for closing arguments. In their closing arguments, they will summarize the evidence to help you understand how it relates to the law. Just as the opening statements are not evidence, neither are the closing arguments. After the closing arguments, you will leave the courtroom together to make your decision. During your deliberations, you will have with you my instructions, the exhibits admitted into evidence, and any notes taken by you in court. The defendant is charged by the state of Idaho with a violation of law. The charges against the defendant are contained in the amended indictment. The amended indictment is simply a description of the charges. It is not evidence. Jury instruction number 3. The defendant, Guy Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Vallow Daybell and or Alex Cox and or other co-conspirators. The crime of conspiracy involves an agreement by 2 or more persons to commit a crime. You must only consider the evidence against the defendant, Guy Daybell, in this case, and should not speculate as to any other case or legal proceedings involving any alleged co-conspirators. You must remember that the defendant, Guy Daybell, has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. Instruction number 4. It is alleged that the crimes charged were committed on or about or on or between a certain date. If you find a crime was committed, the proof need not show that it was committed on that precise date. Instruction number 5. Under our law and system of justice, the defendant is presumed to be innocent. Presumption of innocence means 2 things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. Jury instruction number 6. A defendant in a criminal trial has a constitutional right not to be compelled to testify. The decision whether to testify is left to the defendant, acting with the advice and assistance of the defendant's lawyer. You must not draw any inference of guilt from the fact that the defendant may not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Jury instruction number 7. If during the trial I may say or do anything which suggests to you that I am inclined to favor the claims or positions of any party, you will not permit yourself to be influenced by any such suggestion. I will not express nor intend to express, nor will I intend to intimate any opinion as to which witnesses are or are not worthy of belief, what facts are or are not established, or what inferences should be drawn from the evidence. If any expression of mine seems to indicate an opinion relating to any of these matters, I will instruct you to disregard it. Jury instruction number 8. Your duties are to determine the facts, to apply the law set forth in my instructions to those facts, and in this way to decide the case. In doing so, you must follow my instructions regardless of your own opinion of what the law is or should be, or what either side may state the law to be. You must consider them as a whole, not picking out one and disregarding others. The order in which the instructions are given has no significance as to their relative importance. The law requires that your decision be made solely upon the evidence before you. Neither sympathy nor prejudice should influence you in your deliberations. Faithful performance by you of these duties is vital to the administration of justice. In determining the facts, you may consider only the evidence admitted in this trial. This evidence consists of the testimony of the witnesses, the exhibits offered and received, and any stipulated or admitted facts. The production of evidence in court is governed by rules of law. At times during the trial, an objection may be made to a question asked a witness, or to a witness's answer, or to an exhibit. This simply means I'm being asked to decide a particular rule of law. Arguments on the admissibility of evidence are designed to aid the court and are not to be considered by you nor affect your deliberations. If I sustain an objection to a question or to an exhibit, the witness may not answer the question, or the exhibit may not be considered. Do not attempt to guess what the answer might have been or what the exhibit might have shown. Similarly, if I tell you not to consider a particular statement or exhibit, you should put it out of your mind and not refer to it or rely on it in your later deliberations. During the trial, I may have to talk with the parties about the rules of law which should apply to this case. Sometimes that will occur over on the corner there, and we do have a device here that whites out the noise so you can't hear us speaking there. At other times, I'll excuse you from the courtroom so that you can be comfortable while we work out any problems with evidence. You are not to speculate about any such discussions. They are necessary from time to time to help the trial run more smoothly. Some of you have probably heard the terms circumstantial evidence, direct evidence, and hearsay evidence. Do not be concerned with these terms. You are to consider all the evidence admitted in this trial. However, the law does not require you to believe all of the evidence. As the sole judges of the facts, you must determine what evidence you believe and what weight you attach to it. There is no magical formula by which one may evaluate testimony. You bring with you to this courtroom all the experience and background of your lives. In your everyday affairs, you determine for yourselves whom you believe, what you believe, and how much weight you attach to what you are told. The same considerations that you use in your everyday dealings and making these decisions are the considerations which you must apply in your deliberations. In deciding what you believe, do not make your decisions simply because more witnesses may have testified one way than the other. Your role is to think about the testimony of each witness you heard and decide how much you believe of what the witness had to say. A witness who has special knowledge in a particular matter may give an opinion on that matter. In determining the weight to be given such an opinion, you should consider the qualifications and credibility of the witness and the reasons given for the opinion. You are not bound by such opinion. Give it the weight, if any, to which you deem it entitled. Jury instruction number 9, at the conclusion of the trial, you will decide as to each charge whether the state has proved the defendant guilty beyond a reasonable doubt. The subject of penalty or punishment is not to be discussed or considered by you in making these decisions. That is a matter which must not in any way affect your verdict. Jury instruction number 10. The state is seeking the death penalty in this case. If the defendant is convicted of murder in the first degree, there will then be a separate sentencing phase of the trial. At that sentencing phase, additional evidence may be presented and the jury will be given additional instructions. At the conclusion of that hearing, the jury will then decide if the defendant will be sentenced to death. If the jury decides that the defendant will not be sentenced to death, either the defendant will be sentenced to a term of life imprisonment without the possibility of parole, or the judge will sentence the defendant to a term of life imprisonment during which the defendant could not be paroled for at least 10 years and possibly for life. Jury instruction number 11. If you wish, you may take notes to help you remember what witnesses said. If you do take notes, please keep them to yourself until after you and your fellow jurors go to the jury room to decide the case. You should not let note-taking distract you so that you do not hear other answers by witnesses. When you leave at night, you'll leave your notes here with the bailiffs. If you do not take notes, you should rely on your own memory of what was said and not be overly influenced by the notes of other jurors. In addition, you cannot assign one person the duty of taking notes for all of you. Jury instruction number 12. It is important that as jurors and officers of this court, you obey the following instructions at any time you leave the jury box, whether it be for recesses of the court during the day or when you leave the courtroom to go home at night. First, do not talk about the case among yourselves or with anyone else during the course of the trial. You should keep an open mind throughout the trial and not form or express an opinion about the case. You should only reach your decision after you have heard all the evidence, after you've heard my final instructions, and after the final arguments. You may discuss this case with the other members of the jury only after it is submitted to you for your decision. All such discussions should take place in the jury room. Second, do not let any person talk about the case in your presence. If anyone does talk about it to you, tell them you're a juror of the case. If they won't stop talking, then report that to the bailiff or courtroom staff here as soon as you're able to do that. You should not tell your fellow jurors about what has happened. Third, during this trial, do not talk with any of the parties, their lawyers, or any witnesses. By this, I mean not only do not talk about the case, but do not talk at all, even to pass the time of day. In no other way can all parties be assured of the fairness they are entitled to expect from you as jurors. Fourth, during this trial, do not make any investigation of this case or inquiry outside of the courtroom on your own. Do not go to any place mentioned in the testimony without an order of the court to do so. You must not consult any books, records, internet, or any other source of information unless I specifically authorize you to do so. Fifth, do not read about the case in the newspapers. Do not listen to radio or television broadcasts about the trial. You must base your verdict solely on what is presented in court and not upon any newspaper, radio, television, or other media account of what may have happened. Each day, you will be required, as I mentioned, to sign an affirmation that you will follow this admonition of the court. That concludes the court's first instructions then, and as I mentioned, you will be provided copies of those when you deliberate for further reference. Next, at this time then, I am going to have the clerk read the amended and redacted indictment to you. Madam Clerk, if you're ready to read the amended indictment, please do that at this time.
In the District Court of the 7th Judicial District of the State of Idaho and in Florida County of Fremont. State of Idaho plaintiff versus Guy Daybell defendant, case number CR 22211623, amended indictment. Guy Daybell is accused by the grand jury of Fremont County of this indictment as follows. Count 1, conspiracy to commit first-degree murder and grand theft by deception. The defendants, Guy Daybell and or Lori Vallow and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15, 2020, in the county of Madison, state of Idaho, and elsewhere, including Fremont County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Madison and Fremont counties, Idaho, did willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Tylee Ryan and to commit grand theft by deception. Count 2, first degree murder. The defendant, Guy Daybell, on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and as part of a common scheme or plan for continuing criminal transactions in Madison and Fremont counties in Idaho, were concerned in the commission of a first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being, to wit, either kill Tylee Ryan and or assist in the killing of Tylee Ryan, and or did encourage the killing of Tylee Ryan, and or did command another to kill Tylee Ryan in violation of Idaho. Count 3, conspiracy to commit first-degree murder and grand theft by deception. The defendants, Guy Daybell and or Lori Vallow and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15, 2020, excuse me, in the county of Madison, state of Idaho, and elsewhere, including Fremont County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Madison and Fremont counties, Idaho, that willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Joshua Jackson Vallow, hereinafter J.J. Vallow, and to commit grand theft by deception. Count 4, first degree murder. The defendant, Guy Daybell, on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and as part of a common scheme or plan for continuing criminal transactions between Madison and Fremont counties in Idaho, were concerned in the commission of a first-degree murder and did aid and abet in its commission, were not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being. To wit, did either kill J.J. Vallow and or assist in the killing of J.J. Vallow, and or did encourage the killing of J.J. Vallow, and or did command another to kill J.J. Vallow in violation of Idaho code. Count 5, conspiracy to commit first-degree murder. The defendants, Chad Guy Daybell and or Lori Noreen Vallow and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15, 2020, in the county of Fremont, state of Idaho, and elsewhere, including Madison County, Idaho, and as part of a continuing criminal transaction in common scheme or plan in Fremont and Madison counties, Idaho, did willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Tamara, Tammy Daybell, and did combine or conspire to commit murder, and one or more of such persons did enact to effect the object, combination, or conspiracy. Count 6, first-degree murder. The defendant, Chad Guy Daybell, on October 18 to 19, 2019, in the county of Fremont, state of Idaho, was concerned in the commission of first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being, to wit, did either kill Tamara, Tammy Daybell, and or assist in the killing of Tamara, Tammy Daybell, and or did encourage the killing of Tamara, Tammy Daybell, and or did command another to kill Tamara, Tammy Daybell, in violation of Idaho Code. Count 7, insurance fraud. The defendant, Chad Guy Daybell, on or about October 19, 2019 through October 30, 2019, in the county of Madison, state of Idaho, did with the intent to defraud or deceive an insurer for the purpose of obtaining any money or benefit, insurer or other person, a statement as part of or in support of a claim for payment or benefit, knowing that such statement contained false, incomplete, or misleading information concerning any fact or thing material to such claim, to wit, did present and or cause to be presented an insurance beneficiary form to Life Map Assurance Company in violation of Idaho Code. Count 9, insurance fraud. That the defendant, Chad Guy Daybell, on or about October 19, 2019 through October 31, 2019, in the county of Madison, state of Idaho, did with the intent to defraud or deceive an insurer for the purpose of obtaining any money or benefit, insurer or other person, a statement as part of or in support of a claim for payment or benefit, knowing that such statement contained false, incomplete, or misleading information concerning any fact or material thing to such claim, to wit, did present and or cause to be presented an insurance beneficiary form to Primerica Life Insurance Company in violation of Idaho Code. Signed as a true bill on the 24th day of May, 2021, and signed by the deputy presiding grand juror, acting as presiding grand juror in Fremont County, state of Idaho. And to these charges, the defendant has entered a plea of not guilty.
All right, thank you very much, Madam Clerk, for reading the redacted amended indictment. In this case, again, I will advise the jurors, remember the indictment is a description of charges. It is not evidence. That concludes the court's opening instructions and the reading of the indictment. The jury's been sworn as well. The next matter we would take up then are opening statements. We inquire of the state, is the state ready to proceed with openings?
Yes, Your Honor.
Who will be giving the opening statement?
I will remember.
Very well. Mr. Wood, you may present your opening.